he's just trying to do his job. And ladies, you can't start a fight hitting on somebody. Should a guy hit a lady back? Absolutely not. But you can't fight a guy and then say, oh, don't hit me, I'm a lady. All right, the court is calling 2024 CR 3101B, State of Texas versus Rebecca Jean Alvarez. Could I have parties announced for the record for the state? Defense?
William Davidson.
Okay. And are you Miss Alvarez?
Yes, ma'am.
Okay. And it's the court's understanding a PSI was not done in this case, correct?
Correct.
All right. Any witnesses from the state or defense? Any witnesses?
Yes, Your Honor. Christina Villarreal, who is her girlfriend.
All right. Christina Villarreal, if you'll come forward. All right. Can you raise your right hand for me? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right. You can lower your hand. Make sure you keep your voice up so that the court reporter can hear and I can hear.
Right.
All right. State your name for the record.
Christina Villarreal.
All right. Defense?
Yes, Christina. Can you please tell me your relationship to Rebecca?
She's my girlfriend.
And how long have you known her?
About 4 or 5 years.
Okay. And if this judge sees fit to put her on deferred adjudication probation, will you help her get to any appointment she has to get to?
Yes, I will. I have a car, so there's no need to reason why she can't be able to get anywhere or do anything that she requests.
And are you aware she's had a heroin problem?
Yes, I'm aware.
Do you have a drug problem?
No, I don't have a drug problem, never been to jail.
Okay. And would you tolerate her using drugs in your house or in your premises?
No,
Okay. And do you think she may be a good candidate for probation?
yeah, she's a good person. She has a good heart. She can work. She should be good for it.
Okay. Is there anything else you want this judge to know that might help her make a decision on this matter?
Just we can grant her the probation that she'll comply with everything that you do. Like I said, there's no reason why she shouldn't be able to have a car, have everything she needs. I got it.
Yes, yes.
Any questions?
She's an old friend of mine.
Where'd you,
Just around the way. We know similar people.
like, 4 years ago, 5 years ago?
About 5.
Did y'all meet in a store? Did y'all meet,
Yeah, prior I used to work at 7-Eleven, so came into my store.
have you ever been to prison?
No, I haven't. I've never been to jail either.
She's been to prison.
Yes, I do.
She's convicted of robbery.
It's okay. That has nothing to do. Her past has nothing to do with me. It's the present.
My question was that you're aware of that. Is that
I'm
correct?
aware.
And when did you meet her? What year?
I'm not quite sure. It's about 4 or 5 years ago. If you want to come back then,
2020 or 2019?
if you want to believe so, yeah. I mean, I don't remember. It's been a while.
Okay, well, you said 4 to 5 years.
4 to 5.
It's 2004, 24.
Yeah.
Minus 4 years is 2020.
I mean, if you want to say so. But like I said, I know 4 or 5 years. I mean, going back doesn't really mean anything.
Only one person can talk at a time for the court reporter. Okay?
Sorry.
All right. So what I'm going to ask you to do is I want you to listen to the questions that are being asked of you
Mhm.
and answer the questions. Do you understand?
Yes, ma'am.
All right. State, you may continue.
Thank you. I'm just asking these questions so we get a full rounded picture of
Mhm.
your relationship with her, because you're saying that you're gonna be there for her and
Yes.
help her. Is that correct?
Yes, it's correct.
And when she picked up these cases for possession of drugs, you and David,
Yes, I was thorough.
and then in February of this year, 2024, you're also dating of the robbery. Is that
Yes.
correct? No further question, John.
I'm finished with this witness, Sean.
All right. I have a few questions if there are no objections. All right. So I'm trying to figure out how long have you been in a relationship with her?
Like about, I mean, just recently, like about 2 or 3 months.
All right. Do you have children?
No, I don't.
Does she have children?
No, she doesn't.
Okay. All right. Thank you so much for coming down.
Thank you. Kristen, like this. My next witness is my client, Your Honor.
All right, if you come forward. Can you raise your right hand for me? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you're gonna have to keep your voice up so that so that I can hear and so that the court reporter can hear. You can lower your hand, state your name for the record.
Rebecca Jean Alvarez.
All right, defense.
Rebecca, please understand, only one person can talk with the court reporter. And so it's a little bit awkward as far as the normal conversation, but please remember that. Can you please tell the judge about what your drug problem has been?
Being addicted to heroin. I've been struggling with this addiction for the last 3.5 years.
And since you have been locked up, how long have you been locked up?
Since February 2nd.
And have you had access to heroin in the jail?
No, sir.
And are you clean now?
Yes, sir.
Do you have any more desire to use heroin?
No, sir.
Now, if this judge did put you on deferred probation, would you abide by all the terms, including any type of drug treatment that may be recommended?
Yes, sir.
Do you think you need drug treatment?
Yes, sir.
Now, if you get out, do you have a place to stay?
Yes, sir.
Where?
My sisters or at Christina's.
Can you speak up so she can hear you?
My sister Ruby's or Christina's.
And would you be able to get a job again?
Yes, sir. With my my former, I used to work at Blue Star Brewery and he's willing to give me another shot.
Blue Star Brewery?
Yes, sir.
And what do they do there?
It's a brewery. I was a dishwasher there.
You don't have access to any drinking there, do you?
No, I don't drink.
And are you asking this judge to give you deferred probation?
Yes, sir, I am.
And you're gonna abide by the terms and conditions of their,
Yes, sir.
and this is a first degree felony, even with the waiver of the repeater. So do you understand the range of punishment if you were to get revoked?
Yes, sir.
And what is the lower range?
5,
And what's the upper range?
18.
No.
Oh,
If you get revoked, the upper range on a first degree felony is
99, right?
correct. You don't want to come back here, do you?
No, sir.
They pass the witness?
State.
Yes, on the day, February 2nd, 2024, what were you and your friend doing?
We went to JCPenney's and I was trying to make ends for my drug habit.
Okay, so you were stealing from there? When you
Uh,
left, the knife was pulled on the employees there?
Yes, sir.
You were stopped under a bridge by
Yes,
the
sir.
officers?
Yes, sir.
And you were convicted of robbery, and spent 8 years in TDC, is that correct?
For my past, yes.
Thank you, no further questions, Joe.
Just want to follow up on that. At that store, did you personally take anything out?
No, sir.
What did you do with the merchandise when you,
I emptied my backpack and threw the items inside the store. I never left the store with it.
okay, but you were with someone who did leave the store with it,
Yes,
correct?
sir.
All right, which is probably why you're here today.
Yes, sir.
Now, as far as in the store, was any knife pulled in the store?
No, sir.
What was the purpose of the knife being pulled outside of the store?
He was pushing on her. And he's a male. I mean, she's a female. He didn't identify himself. He didn't say he was loss prevention. I mean, after he said he was going to tackle her, I felt the need to step in and I pulled out a pocket knife.
Did you cut anybody?
No, sir.
Okay. That's what it's.
He didn't identify himself,
No, he didn't.
so he just ran up to you
Yes.
and grabbed you
He put his hands on her.
on her,
Yes.
and so you pulled out a knife.
Not till after he threatened to tackle her and we were already out the store. And I already had opened my backpack and gave him the items. Like, I never left the store with any items.
Maybe you did, but your friend did, that you pulled the knife out for the protector, right?
Yes, sir.
So you knew who the person was coming to stop you.
That didn't happen until after he didn't identify himself. He went to go push on her.
Did you or did you not know who the person came to stop y'all from stealing?
Once I put the knife out, I guess, yes.
Okay, no further questions.
I don't have any more questions, John, but if you do, have no objections. You are asking for deferred,
Oh, just one moment.
sorry.
All right, I'm reading the stipulations and it states Rebecca observed Damien following her. So she told him she was not stealing anything. Rebecca removed items from her backpack and walked out the exit door. So the person who was following you all was Damien. And in the stipulations, it says you observed him following you and you told him, you actually spoke to the person. So the person who came running after you and the friend that you were with is the same person who you said, I'm not stealing anything. So are you still saying that you didn't know that this person worked security or was an employee of the store?
I don't recall telling him any of that.
Okay. And what is your relationship to Rebecca? I'm sorry, yeah, what is your relationship to, um, just one moment. Who is this? We always have people who want to be attorneys. All right, what is your relationship to Corianne Valent?
None, she's an ex.
All right, so that's your ex-girlfriend that you were with?
Yeah.
All right, and so while you were with her, I'm not trying to start any trouble, but while you were with her, were you still with the person who came to testify on your behalf? Because her timeline of dating you is during this incident.
Corinne was an ex. We weren't in a current relationship.
Okay. All right, I always just have questions. Okay. All right, any other witnesses from either side?
Nothing from the state,
No, yeah.
All right, the court will hear argument. State.
state's asking for 18 years.
I'm sorry, you said you're asking for 18 years. There's only one case, correct?
There should be 2 cases going on.
All right,
Is there
let
2
me
cases,
see.
right?
I thought it was one case and I
Oh,
thought
sorry.
Yes,
I
I
thought-
only have one.
the enhancement was waived. No, not waived, but
Oh, sorry. He gave me 2 cases.
I'm sorry.
Okay, so there's only one.
18, yes, sorry, I apologize.
Another case, my fault. It's another case.
No problem.
Your Honor, I'll give you those were for the other one.
I'm sorry.
I didn't read the name on the file.
I'm sorry.
Okay. All right, defense state is requesting 18.
Your Honor, we are requesting some type of deferred, obviously it can only be up to 10 years for deferred that actually take place. My client is willing to do whatever she has to do to comply with the terms and conditions of probation. She does have a support system that we're here. And she is willing to go to any kind of drug treatment that's recommended or required. And she knows that if she blows this, she's looking at possible 99 years of, you know, not that that's always given, but she could get a long time on this thing. She did not take anything out of the store. However, she was with someone who did. And she apparently pulled a knife, and what she says is a defense of this other person outside the store. My client at that time was homeless, living under a bridge, which is, I think, where they arrested him. So we are asking for deferred.
All right, so, Ms. Alvarez, I want you to know that I understand that any time that somebody does in custody, it's a lot of time. I remember when I was a defense attorney, you would have some prosecutors saying, oh, a person can do that time standing on their head. And you know, I always tell that prosecutor, have you ever done time? Because if you have not, you can't tell me that somebody can do time standing on their head. But both you all have talked about your prior, which is a robbery. So a robbery, the difference between that and aggravated robbery is there's not a weapon. And so you've gone from committing a robbery that you went to prison for to now it's aggravated robbery. And I don't know why people who are in the wrong feel the need to pull weapons. I mean, both you, from what I read in the stipulations, both you and the person, your ex that you were with, you all were stealing from JCPenney at North Star. And this person is just trying to do their job. I don't know if he receives a bonus from stopping theft or not, but he's just trying to do his job. And Ladies, you can't start a fight hitting on somebody. Should a guy hit a lady back? Absolutely not. But you can't fight a guy and then say, oh, don't hit me, I'm a lady. You can't steal from JCPenney at North Star and then say, oh, don't chase me, don't grab me and bring me back to the store because I'm a lady. You understand?
Yes, ma'am.
All right, this is what the court is going to do. The court is going to find you guilty. There's an affirmative finding of deadly weapon. Court is going to sentence you to 18 years in the prison. You're credit for any time served. There's to be no contact with Corien, Corien, Valent, Valent. There's to be no contact with North Star Mall. And there can be the therapeutic community. If you have a drug issue, the therapeutic community does not increase the time that you're in custody. But I have no jurisdiction to force them to allow you in the program, so you'll have to request it. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. We can go off the record. Here's the thing. If you pick up another felony in Texas, depending on the level of felony it is, that's going to put you in a status as being a habitual offender, and your minimum will be 25 years, and you will not be eligible for probation. Do you understand? All right, good luck to you.
May I say one thing, Your Honor?
Yes.
And I'm sure the court's already aware of this. I just need to state this to make sure it's on the record. There were two counts. The first count was ag robbery. The second count was robbery.
Yes.
That doesn't change, what she did or didn't do, but the count one had been waived.
Yes, no, the count that was waived was count two.
Yeah, so this,
Yeah, count two was the one that was waived.
The ag robbery was waived.
On the repeat.
No, let me see the file.
I promise you, it was the ag
Okay.
robbery, but they did say that they kept the repeater because they wanted it to be a first degree.
No. Count two was waived and the enhancement was waived, and they proceeded on count one, and count one is the aggravated robbery. All right, thank you. All right, could I have someone for the state? It's Criminal Trial Division. Court is calling 2024 CR 4983, State of Texas versus Jessica Marie Bonner. Can I have parties announced for the record for the state? Defense?
Sean Sheffield.
Are you Miss Bonner?
Yes, ma'am.
Counsel, have you received all of the discovery? Did you review it with your client?
I did hear.
Ms. Bonner, did you sign the document entitled Application for Deferred Adjudication or Community Supervision did you sign that?
Yes.
And did you review it with your client? Did you review the document entitled True Bill of Indictment with your attorney?
Yes.
Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right. Did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it?
Yes.
Did you sign it in all the appropriate places? Did you understand you're charged with the offense of fraudulent use of possession of identifying information, less than 5 items, elderly person? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, sir.
Ms. Bonner, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, there's a $2,500 fine. State is recommending deferred adjudication. There's to be restitution to Caroline Caldwell. Did you understand that to be the plea?
Yes, ma'am.
Defense,
Yes, sir.
state?
Yes, Your Honor.
Did you agree? All right, so everyone, we're on the record. No talking behind the court reporter. If you need your person moved to the other end, they can be moved to the other end. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Clear.
Outside the agreement, state is requesting that your deferred adjudication be for a term of 8 years. There be a TAP evaluation, 200 hours of community service restitution, and no contact with Caroline Mullins Caldwell. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contact.
State any evidence.
Contained in exhibit 1 and attachments, Your Honor.
No objection.
All right, you may be excused.
Thank you, Your Honor.
Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney?
Yes,
Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent. Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, sir.
Anything you wish to say on behalf of your client?
Your Honor, we just asked the court to follow this recommendation.
All right, what's the name of the complainant's son who allowed you in the home?
it's David Caldwell.
What's your relationship to him? All right, do you have any children?
Yes, I do.
What are their ages?
18 years old, 17 years old, 16 and 15-year-old.
And who are they with?
They're with their dad right now.
What's your drug of choice?
I was on meth, but been clean.
All right, were you clean when you committed this offense?
No, ma'am.
All right, so why are you taking things that don't belong to you?
I was in the wrong place. I needed money at the time with my kids and it was just opportunity and it was wrong for me to do it.
Who is Melissa Campos?
That I have no idea.
And is Child Protective Services involved in your case?
I don't think so. I'm not sure.
When's the last time you had employment?
Well, I was working as a cleaning houses and then I lost that.
Mhm. All right. Anything else?
No, sir.
This is what the court is going to do. Court is going to sentence you to a $2,500 fine. That will be probated,
Thank you.
8 years deferred adjudication. There's to be no contact with the following persons: Caroline Caldwell, David Caldwell, Melissa Campos. There's to be no unsupervised contact with minors. There's to be a referral to felony drug court. That'll be first. A TAP evaluation in custody. And then last, if none of those places accept her, then we can do a referral to Esperanza Court and follow TAP recommendations if she's not accepted in one of those treatment programs. There's to be the UA hotline, regular reporting by Zoom or in person, field visits 1 time per month for 4 months, then at probation's discretion, proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors or in housing. You can't be cleaning houses or any place where you're around money or checks. You understand? 200 hours of community service restitution. I'm going to order parenting classes. Once you complete parenting classes, the community service hours will be deemed satisfied. And there's to be restitution, if any, to Caroline Caldwell. Probation, is there anything else she needs? Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. In this court, to be successful on probation, communication is key. If there's an issue, let your probation officer know. If you feel as your probation officer is not addressing that, you can come to court. We're here, but not on weekends or holidays. If you feel like you're going to use, pick up the phone, call your probation officer. And again, if they can't get you any help, come back to court. You understand?
Yes, ma'am.
All right, thank you. All right, court is calling 2024 CR 1544, State of Texas versus Francel Braggs. Could I have parties announced for the record for the state
Andrew Harris settlements.
defense?
Michael Dwight going to the defendant, Your Honor.
And are you Mr. Braggs? All right, so the court ordered a TAP evaluation. It appears to the court that the defendant has a drug problem. And it's for possession less than a gram case. And I understand the reason for the state's opposition. And I'm sure it's because of the prior offense. Because otherwise, this is just a possession less than a gram case. So state, I know you're opposed to the application. Is that correct?
Correct, Your Honor.
So, Mr. Braggs, is he currently on parole for the repeat offense?
No, Your Honor.
Has he satisfied that sentence?
I don't believe so, Your Honor.
Yes, ma'am, I
Okay.
have
All right, what was he sentenced? What were you sentenced to? How many years?
25 years.
25 years? Yeah,
I-
he satisfied the offense. I mean, he satisfied that then.
I did 25, I did 22 and a half years inside, and I got out and finished parole, and I've been out from my prior case for 14 years.
Okay. All right, so sometimes I can give people choices, sometimes I cannot. I know that when people look at defendants, they look at their history, right? To make a decision on whether or not somebody should be given probation. I understand that sometimes that's what people are going on. It's not the new case. So looking at what you were sentenced for and how many years you received and the fact that you're no longer on parole, then yes, I'm considering that. And I'm going to put conditions in place to address that. But this is a possession less than a gram case, ultimately,
That is
that
correct, Your Honor.
has been enhanced to a third-degree felony. So I'm going to give you a choice. Here are your choices. Some people say being on probation out of this court is very hard. So I can sentence you to 3 years in the prison, or either I can place you on probation. And you're going to be found guilty and you'll be placed on probation, or I can sentence you to 3. Which do you prefer?
Probation.
All right. So this is what the court is going to do. The court will find you guilty. Court is going to sentence you to 6 years in the prison, suspended. Any suggestions on how long he should be on probation, state?
6 years, Your Honor.
All right, defense?
Request for, Your Honor.
All right. Let me think about that and I'll come back.
Yes, sir.
So there's going to be regular reporting. And you're going to have to report in person because the nature of your prior charge, I don't think they'll allow you to report by Zoom. Probation, if you all allow him to report by Zoom, that's fine. But if not, you don't have to. There's to be proof of employment. When's the last time you had employment?
November 2023.
All right, so there's going to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's going to be random, regular UAs, field visits. Somebody has children up here?
That sounds in the hallway, Judge.
And see, that's a young baby, and this courthouse is so germy. People just don't realize, and children don't even have their immune system built up yet. So it's gonna be field visits 1 time per month for 6 months. And then at probation's discretion. 120 sober meetings and 120 days. And we're going to do supportive outpatient treatment. And the state is taking in consideration night mag numbers 759930. And the court is going to place you on probation for 5 years. If you complete everything successfully, then he can always come back to the court and ask to be terminated early.
Thank you, Your Honor.
Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
No, I just want to thank the courtroom very, allow me to stand on my foundation and go back and do what I need to do. For me and my family.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
And you understand that based upon the nature of your art of the charge, you still have to make sure you stay in contact with them as well.
Yes, ma'am.
All right, we can go off the record. In this court, to be successful, communication with probation is key. Do you understand?
Yes, ma'am.
If there's an issue and you need help with something, ask probation. If you feel as though they're not addressing it, you can always come back to court. We're here every day except weekends. All right, good luck to you.
Thank you very much.
All right, you're welcome.
Your Honor, may I be excused?
Yes.
Your Honor, does he need a thumbprint on?
Oh, they'll take care of it. The deputies will. All right, Carly Green.
We filed a motion to modify bond. I'll give a copy of the state and hopefully, but we'll,
I mean, do you want to hear that right now?
it's, possibly.
You know what, it's saying May 25th. It's already passed.
May 25th.
Yeah.
But, oh, we just, he filed it last night. It may not even be the file.
Oh, okay.
Yeah, it's all right.
All right, so you're in jury trial?
Yes, ma'am.
All right, so everyone, please whisper. When do you think the trial will conclude?
Thursday afternoon.
All right, so when do you want this called back? Because I know sometimes you have to have some downtime from a trial.
Well, I'll say this, I'm out of town the first 2 weeks of July. Going to Canada, right? So sometime either between then or after that, if that makes sense.
All right, so you want July 15th?
We get back on the 16th. I would say the 17th or later would be ideal.
All right, you want to do it the 18th?
That works.
All right. All right, and so when you come back on the 18th, we're going to give you your jury trial date for this.
Sounds good, Judge.
All right, once you sign the reset form, you're excused.
Thank you, Your Honor.
All right, and I talked to you about being late last time and you're on time.
Early.
Yeah, you're early. And
I
thanks
made
for,
sure.
thank you. And Drace, thank you for dressing appropriately for court.
Phone number on the bottom, I'll get you. Oh, you're lucky. Coming in under the phone number, just, yeah, the some on the bottom.
Okay, I just noticed we have the old docket sheet back.
Yeah.
Okay. Jose Gonzalez.
Well, Your Honor, he's on Zoom. We're ready for the CPS records and apparently the date's been told they won't have until July 29th.
All right, state. Family violence. All right, Jose Gonzalez, are you there?
He says he's waiting to get let in.
Is this Jose
Yes,
Gonzalez? All right, sir, you need to find a seat. All right, so CPS records.
I don't know anything about CPS records, but I was told that July 29th is when they'll be ready, apparently, is what they communicated to the DA's office, so.
Yeah,
Why?
I don't know.
Huh?
CPS just sent me an email yesterday saying they're not gonna be ready until the 29th of July.
Okay, so here's my question. It appears, is Child Protective Services involved in this case?
I don't know, Judge, we have not, she did confer with the state through our advocate, we have not spoken, this was, the person that no longer is in this court had this case from the start point, so. I am not up to speed on this case.
All right, because
Yes,
it,
Judge, there's a CPS case.
and there's a CPS case that's open.
I believe it's still open, yes.
All right, so there shouldn't be any problem with CPS records for July 29th. All you do is go over to the state's attorney on the CPS side, and they should have all the records.
Our process is typically just subpoenaing the records through our normal channel, and if they tell us the 29th, I'm not sure what else I can do.
Oh, just go to the prosecutor who has the CPS case, and they have the records. They're actually in the process of trying the case. That's what defense is telling me, that she believes that there's an open CPS case. If the CPS case is open and still pending, that means that the prosecutors in CPS court have all these records. Otherwise, they wouldn't be able to have their case going in CPS court.
I don't know if it's open or closed, Your Honor. I'm
Okay.
happy to look into that today.
Okay.
But again, this was one that was an ADA that's not in this court anymore.
Okay, all right. I'm recalling this for July 8th. All right.
Is it for the pretrial judge?
Yes, it's for the CPS records.
Which I think, is that the week after the 4th?
Yes.
Okay, I think I'm good then. Thank you.
All right, see y'all then.
All right, thanks, Judge.
All right, thank you, sir. Thank you for
Thank you.
dressing appropriately for Zoom.
Yes, ma'am. Appreciate y'all. Thank you.
You're welcome. All right, so here's my question. I don't know anything about your case. This manslaughter case, is it involving a vehicle?
It is.
Okay,
Both parties were in a vehicle.
all right. So this is, I guess, alleged to, well, the state is alleging it's manslaughter. I'm assuming there's
We,
accident or
it
something.
is, and the
Okay.
point of contention is gonna be causation, so that's gonna be a heavily litigated issue.
All right, we're gonna go on the record. Court is calling 2023 CR 8868, State of Texas versus Samuel Brock. Could I have parties announced for the record for the state?
Andrew Harrison.
Defense,
Jody Sawyers,
and are you Mr. Bach?
ma'am.
All right, defense has filed a motion for continuance. State, do you have any objections? All right, so this case has been going on in this court since January 2024. And I'm just receiving information that there may be medical records for the complainant. Why am I just now receiving this?
that's a great question. The state asked for 3 continuances while they said they were talking to the complaining witness, and we thought we were gonna work this case out. And when they talked to the complaining witness, they still had to talk to their superiors, so the state got 3
Right,
continuances.
complaining witnesses, it's a manslaughter that they,
Their family, his
Ah,
family.
the family,
I
okay.
apologize. To be clear, his family. So, I mean, we thought we were gonna resolve this case. And that's what we were led to believe at the last setting that we had. We were not able to resolve it. And that is what shifted gears. So we are not, I mean, we have the records, but we don't have the records that are behind the autopsy report that we now need, because as I put in there, the drug screen initially says no drugs detected. But now I need the underlying data because I have something that actually contradicts the fact that this particular complaining witness would have and should have had stuff in his system.
so you're assuming that because he was prescribed these medications, he was taking these medications?
Well, he said the day before to his doctor, he was taking them. So that, and coupled with the fact that I need to see what they screened for, it's possible that they didn't test, that these wouldn't have triggered, and I need to know that. So that's where we're looking for that data as well from the state, as well as we need time to get experts, which we believe it will take us approximately 30 to 60 days. I'm asking for a reset toward the end of August.
Okay, I can tell you right now, we're not doing 30 to 60 days for a jury trial. You all are coming back because this is an old case. We've been dealing with discovery since January. And I know people don't think that's old, but in this court, that's old. So this is what's going to end up happening. We're coming back and we're coming back on July 15th. On July 15th, state whatever records you have from the autopsy report, whatever medical data as it relates to drug testing needs to be turned over at that time or before that time to the defense. And defense, you need to specifically address with the state what you're looking for with regards to those records. And then you all need to be off record and talk to the inmate and see where the toxicology report is. Does everyone understand?
Yes,
The records that you've received, they're gonna have to have been reviewed by the 15th. Okay?
now, Your Honor, just to let the court know, I have had a vacation letter on file for the 15th through the 22nd for months now. It's my 50th birthday.
Oh, no, you gotta celebrate your birthday. So we're gonna come back on July 10th.
Yes, thank you, Your Honor.
All right. Oh, and happy 50th.
Thank you.
They say that's the best one.
Ted keeps saying it only comes around once, and I was like, so did my 49. I don't
Yeah.
understand why we're.
And you know, when you tell people you're 29, that's the one that they don't believe. Because when I was 29, they're like, you're not 29. Either, nobody is ever 29. They act as though that age does not exist. But oh, when I was 50, those were the days. All right, once you sign the reset form, you're excused.
Okay, thank you, Your Honor.
You're welcome.
Have a good day, Your Honor.
Thank you, and thank you for dressing appropriately for court.